Hello, good afternoon, guys. Hello, everyone. I hope all is going well. I hope you guys are doing great and you can see me live and colored and clear. Welcome, everyone. So, we're still continuing on our RFE and NOID series. RFEs, request for evidence, NOIDs, notice of intent to deny. As usual, we're spilling some US immigration law tea. Welcome, everyone. If you join late, you're welcome. And if you're watching this from YouTube, you're very welcome. Special welcome to you. Always please subscribe, like, share, comment on the video so that more people can get to see my videos. All right, people, I'm so excited to come your way. I'm a little late today. It's been quite a busy day for me, so I just wanted to drop by so that we still discuss a few minutes of US immigration law. We're still talking about request for evidence and notice of intent to deny. So if you file any type of US immigration law application and then you receive a letter from the U.S.A telling you that, look, we're requesting for further evidence, or look, we have the intention of denying you, and so you have to supply further evidence or tell us why we shouldn't deny you or whatever. So we're looking currently at the policy memo that the U.S.A uses to review some of these RFEs and NOIDs. Okay, so let's get right to it. As usual, I'll share my screen. You know that it's coming directly from the law. We continue with this very exciting topic. So we're going to look at considerations. These are some of the considerations that the USCIS, United States Citizenship and Immigration Services, they look at before they issue an RFE. Okay, guys, drop me some comments. I'll come read some comments and then we'll see how you all are doing this week. So here are some of the considerations. Initial case review should be thorough. So this is clearly a policy guide to the reviewers. They have to always review cases thoroughly when we submit applications. And sometimes an officer would have to assess whether the information that they need is readily available in the USCIS database or system. So, for example, a petitioner may be, a reviewer, USCIS reviewer or adjudicator may be wondering, this person is currently applying for a marriage-based green card. Does he have any, has he ever applied for such an application in the past? And what happened to that marriage? Okay, so clearly any type of US immigration law application for a marriage-based green card goes through USCIS. So USCIS will not need to issue an RFE for that inquiry. They just need to go to their database, because if there's been a marriage-based green card petition, that will be on the USCIS data files, and they will have access to all of this in their systems. And so that is not a matter for an RFE issuance. So, okay, then occasionally certain evidence or information not submitted with the application, petition, or request may be readily accessible in other USCIS record or other external sources. So again, guys, this is a caveat. Remember that other external sources, it could include Facebook, it could include, courts, it could include just any public information or any external sources. So be careful about providing inconsistent information. Watch your back, know what you're submitting to the government, because they have ways of verifying and corroborating things that you have submitted. Okay, so if such information is available in USCIS databases or systems, an officer may obtain the information from these sources, again, rather than, of course, issuing an RFE or a NOID. And then look at this. Adjudicators have the discretion, I've highlighted this in green, to validate assertions or corroborate evidence and information by consulting, again, USCIS or other governmental files database, by obtaining publicly available information. Like nothing is out of their reach. They can go to your social media and check. Sometimes some people would file a marriage-based green card and it's all transactional. They've paid for these marriage-based green cards. And then, they say, John says he's married to Mary. And then John is on Facebook celebrating Rebecca as his wife in Ghana, or his wife in Nigeria, or his wife in Uganda, or Cameroon, or Dubai, or whatever. That is clearly inconsistent, because you're telling the USCIS, the government, that look, Mary is my wife, she's my bona fide wife, I want to get a green card based off of the marriage to her. And then you're flaunting another person on social media saying that that's your wife. Okay, so that clearly you're going to receive an RFE for some of these things, and that will be inconsistent information, and that will be derogatory to your application. So be careful of all these things. An officer should not request evidence that is outside the scope of adjudication or otherwise irrelevant to an identified deficiency. Again, as we said, remember, RFEs are issued for, packets that are deficient in terms of evidence. There's, sometimes there's an evidence that is needed to clarify or to bolster a point you are making, or to bolster your eligibility for a request. And so if they request for the evidence, and that will help, and then the evidence would help say that, oh yes, this person qualifies, then they should ask for it. Okay. So for example, here we're talking about evidence that is sometimes irrelevant. Like somebody may be filing a green card application for their child, a US citizen for their child, and then you go and ask the person that, bring us a list of all the boyfriends you've slept with in the past 10 years. That is clearly irrelevant, and it's is absolutely outside the scope of adjudication. And so the RFE should be relevant to the identified deficiency, and so that is the standard of test. And so yes, if you are issued an RFE that is clearly outside the scope of adjudication, of course consult with an attorney, and then they'll be able to respond adequately to these people and let them know that the applicants are not required to comply with that RFE request, because this is it has to be relevant. Okay. In general, officers may but are not required to issue RFEs or NOIDs. Again, we're still looking at the 2018 memo, guys. Remember, this is a higher standard. Now the officers have more discretion, and they retain discretion to deny a request for ineligibility without issuing an RFE or NOID. And so they can straight out and flat out deny you without resorting to an RFE, without telling you that, hey, look, do you have any evidence to give me? I'm about to deny you. Or, hey, look, do you want to help clarify this in my mind, because this looks murky out here? They don't have any requirement to do that. They can flat out deny you. So again, the entire burden is on you, the benefits requester, to make sure that you're submitting a full, complete packet that has all the relevant evidence, that has all the credible evidence, that has all the probative evidence. Okay. Relevant evidence that is relevant to the benefit request that you are seeking, and that establishes proper eligibility for it according to the statutes. Okay, so the other thing is that we're going to now look at the factors, what is supposed to be contained in an RFE. Let me scroll down. I'm sorry, I got such a really bad cough. And so please forgive me if you hear me coughing. I haven't been feeling too good, but all is well. Guys, drop me some comments, show me some love. There's no interaction, guys. Come on. Oh my goodness. Where is my screen? Right here. I come on live because I want to interact with you. I don't do pre-recorded anymore because the interactions are good. So show some love, drop some comments, and then I'll be reading them very, very, very soon. I'm still actually struggling to find my screen. Then I can, okay, I think I found it. Good. Is this it? Oh my goodness. I don't know what's going on. Please stick with me. I just want to, okay, great. I found it. All right, right here. Yeah, we're almost done. So we will just chat up to the end of this screen, and then I can release you guys to go have your dinner or, do what you're doing. Okay, so when an RFE is appropriate, it's supposed to have, 4 factors. So the first one is that the request for evidence must identify the eligibility requirement that has not been established and why the evidence submitted was not sufficient. Okay, so It can tell you that, hey, to be eligible for a marriage-based green card, for instance, you have been married 2 times and this is your 3rd marriage. You know, tell us why you're eligible, because your prior marriages, we want to see proof that, you know, they were properly dissolved. Send us your divorce certificates. Okay. Because normally you're supposed to send divorce certificates of prior marriages and then the marriage certificate of the current marriages. So sometimes you'll be asked that, look, they will identify the eligibility requirement that you're supposed to be in a full and valid marriage to, let's say, a U.S. citizen. And then they tell you why the evidence submitted is not sufficient. They want to see that have all prior marriages between both the petitioner and the beneficiaries been properly dissolved, you know, freeing both parties up to enter into the current marriage, which forms the basis of the current application. That's the first thing they're looking at. Okay, so normally the RFE, the request for evidence, will identify what the eligibility requirement is, that you're supposed to be married to a U.S. citizen or a green card holder for a marriage-based green card. And then number 2, it will establish why they feel like, you're not proving it enough. It's not sufficient. The second one is that they will identify any missing evidence specifically required by the applicable statute. And then they'll identify it and tell you that, oh, so you haven't submitted prior divorces. This section of the CFR requires that you're supposed to do this and do that and do this, okay? Just as an example. Then thirdly, identify examples of other evidence that may be submitted to establish eligibility. So for instance, for an I-130, which is petition for an alien relative, let's say a mother is petitioning for her daughter, a U.S. citizen daughter. And sometimes birth certificates, as I was telling you the last time, the U.S.CIS loves birth certificates that are issued contemporaneously with the birth of the beneficiary. Okay, so if you're born in 1990, they expect a birth certificate to be issued in 1990 or very, very, very shortly thereafter. If you're born in 1990 and the birth certificate is issued 10 years later, oh la la, they're going to have issues with you. They're going to be like, how do we know you didn't fabricate this? Because people use it to, you know, claim that they are the father of a certain child, or they are the stepfathers of a certain person. And, you know, it's you know, there are schemes surrounding all of that. So when, for example, there is this birth certificate that is issued after so many years after the birth of the child, normally they would ask you that, look, bring baptismal certificates establishing mother and daughter relationship, bring records from school establishing mother and daughter relationship, bring, you know, medical records and all sorts of records like naming ceremony records or whatever kind of records you can get to establish eligibility. So they'll sometimes tell you that these are secondary evidence, and then they'll tell you, sometimes they'll even tell you bring a DNA if you want. Of course, it's not required. So normally the evidences are categorized into 3. There's always a primary evidence, there's the secondary evidence, and then there's the tertiary evidence. Tertiary evidence, for example, when it's a relationship between a mother and child, can be affidavits from people that know you and say, oh yeah, that is the mother. I was there when they were, you know, she gave birth to this person, she gave birth to this person, that is her child. It's, you know, word of mouth of somebody. And so that's not valued as highly as a birth certificate that has been issued by the hospital or by, let's say, the authority that's supposed to issue birth certificates, and it has been issued contemporaneously with the birth of the child. That is primary evidence because it's incontrovertible. Like, let's say in 1980, when you gave birth to the child, you were not contemplating fabricating evidence for a benefit that you were going to seek 30 years later. Okay, so that is very believable and very, very highly credible. And so that's primary evidence. So sometimes the RFE will identify that, look, if you don't have primary evidence, bring secondary, bring tertiary, and this will help you to establish eligibility. And then finally, it will just request that evidence. And so it doesn't end there. They will identify that, okay, do you have this? If you do, bring it. Do you have this? Do you have a baptismal record? Then bring it in. So they would identify the examples of evidence and then request specifically the evidence that you're supposed to bring, so that it's clear in your mind what you're needing to take. Because you don't want issues where it's not clear, like you receive an RFE and you're confused about, you know, how to address it. Okay, the RFE again should ask for all the additional evidence, and yeah, it will usually also state a deadline. So usually, and in fact, currently 60 days has been added to the period of time that the RFE is requested. So normally, of course, things have slowed down because of the remote nature of work. Now, if you're given a date, usually it's 60 days from that date. But of course, as I would always say, consult with your attorney to be sure your case is covered, okay? Because it's not everything that is covered by this. So my number is down there, 802-7800-564. If you need help, just don't hesitate to call me, and then I can review your situation for you. Okay, then the officer's careful consideration of all the apparent gaps in the evidence will minimize the issuance of multiple RFEs. I think we talked about this the last time. And then again, failure to submit requested evidence which precludes a material line of inquiry will be grounds for denying. We discussed this in the last video as well. Either the last RFE video or the last two, maybe part 2 RFE video or part 3. I can't quite remember, but this was addressed as well. All right, guys, we're keeping it short and sweet as always. Well, not as always, as recently. So yeah, we just started keeping it short and very, very sweet. And so I think that we've had enough U.S. immigration law discussions for today. And guys, well, I'm so happy that you stuck with me. You guys didn't comment. I don't know who's watching. Well, anyway, I hope you are doing well and you enjoy this video. I hope to see you guys again, hopefully tomorrow if God gives us life. So be safe, take care, and protect yourself. All right, have a good evening, guys. Bye-bye.